Justice Kavanaugh?
In response to Justice Alito, I think you said that drugs are distinct from alcohol for Second Amendment purposes, although there's some similarities. Is that accurate?
Yes, and I would say that, yes, I can elaborate.
Please elaborate.
Okay, thank you. So drugs are similar to alcohol in the sense that there is a similar history and tradition with respect to identifying people who, by use of the intoxicants on a habitual basis, present on the how and why spectrum special danger of misuse. Drugs are different in a couple of ways that I think make this an easier case. One, we've talked about it a lot, it's illegality. The externalities and additional features of being involved in the illegal drug trade increase the risks. And there's also an additional notice requirement that makes this unlike, you're doing caffeine or sugar. You know that you are already using something that's unlawful to possess, and I think that helps clarify the boundaries of the prohibited conduct. Two is the post-ratification history is worlds apart. As the question with Justice Alito illustrated, there is no post-ratification history or a history of saying habitual drunkards, but also anyone who casually drinks on Fridays or sort of who drinks at parties can be disarmed. That is starkly different from the tradition with respect to illegal drug users. Now, respondent has pointed out that some of them cover addicts, but I think the clearest ones that I would give you that definitely cover unlawful drug users and hark to the time that the problem existed are states like Hawaii, Maryland, Maine, Minnesota, Missouri, Nevada, New York, Ohio, Tennessee, Utah, West Virginia. There's a bunch of them. I could go on with respect to other ones. I think those are the clearest, and that shows that there is a historical judgment that illegal drugs are different, again, for kind of the reasons we talked about for the Controlled Substances Act. There's a judgment that because of their dangerousness, because of the abuse potential, because of other effects, they're unsafe at any level, and it's really hard to figure out at what point does that come.
Do you agree that there's more of the state laws, though, target addiction than simple user?
I'm not sure I would concede that. I think it's a little hard to parse exactly what all of them cover. I think a lot of them do cover addiction, but a lot of them also cover unlawful users. And I'm not sure that would be dispositive when, if you're looking for a post-ratification consensus, you'd have to take the position that all of these laws that are pretty long-standing for people who are mere habitual users of illegal drugs are unconstitutional.
Assume, even though I think you disagree, I know you disagree, assume for a second that there is a history of drug addiction, drug addicts being disarmed, but not so much for users. Just assume that for a second. Then I go to how you define the terms in this case, and this is picking up on something Justice Gorsuch was just asking, but it seems how you define drug user merges with addict in the sense that you've added the word habitual, and then when you turn to the definition of addict in the Controlled Substances Act, it does say someone who habitually uses any narcotic drug so as to endanger the public morals. That's enough. And I don't know how a habitual user is distinct from a habitual user who endangers the public morals.
Right.
So if that's true, the two definitions merge. That helps you on the history, if I'm right, in the hypothetical I posed about the history being really targeted at addicts.
A couple responses. One is we resist the idea that the Controlled Substances Act definition itself is ported over. The part of the Controlled Substances Act that is textually ported over is just the definition of illegal drugs. That's because the definition only covers narcotics. That would be a real problem for us in defining who is an addict versus an unlawful user. Second, with respect to how clear is the definition, I would remind the court the case comes to the court with the proposition, universally accepted by the Court of Appeals, that someone who repeatedly uses marijuana multiple times a week is in the heartland of an unlawful user. And when you're trying to tease out who is an unlawful user versus addict, I agree with you.
And why are they not in the heartland of an addict? So just parse that out for me.
Because it is not clear whether Mr. Hemani could voluntarily cease the conduct. Addict is defined by sort of an internal compulsion to use. An addict can include someone who isn't actively using right now, but has an uncontrollable compulsion to use whenever they get access to the substance.
So is addict misdefined in the Controlled Substances Act then?
It's defined correctly for the purposes of that act, but Congress did not port that definition over into 922G3 because, again, the only thing it ports over is the controlled substance. And this is not sort of an unusual view. It's what the Court of Appeals have recognized, based on the dictionary definitions, that this is an overlap, it may well be overlapping categories of people, but we're giving them distinct meaning, and that this is something that constrains the government in prosecutions, and an unlawful user is judged by a high frequency of use. That's the objective test.
Let me, on a different front, mens rea. How does mens rea work here given rehave? What do you have to prove that the defendant knew about habitual?
Here's what you have to do. One, you have to know that you're using an illegal drug, and I think that's an important constraint just right out of the gate. Two, you have to know that you're using with how many times you're using it. You don't, in the government's view, have to know the legal definition of habitual, but you do have to know, like, if I use marijuana 4 times a week, I have to know I use marijuana 4 times a week. So the conduct that would put me in the category of habitual, I must know. I think these are virtues of the approach here. The government doesn't normally like rehave a lot, but in this particular context, I think it helps impose meaningful limits to the extent the court is concerned with how broadly unlawful user goes above and beyond the constraints courts of appeals have identified, and this is something Chief Judge Colleton also pointed out. The knowing requirement does work here that is important.
Do you think the government could prohibit a habitual drug user from owning a car?
Owning a car with, I think that, I guess there would be various challenges with respect to taking as in other types of property, and I think you would have a different, probably not, but the question for Second Amendment purposes is a different one, which is, are you someone who presents a special danger of misuse in that tradition? So for takings purposes or whatever else the constraints are in that
It's
transaction.
just, it's a danger to have drug users, obviously, driving cars.
And I don't think you would find a history and tradition of saying, I mean, I think you could say there's a tradition of confinement and other restrictions, but with respect to the Second Amendment, the question is, do you present a special danger of misuse for firearms because of a historical category? Just like for felons, you probably wouldn't say you can't have a car, but as the court has recognized from Heller onwards, it's presumptively lawful to identify felons and the mentally ill as categories that may present a special danger of misuse.
Thank you.